It's my goal that when I'm done today, you're going to walk away learning something about what can you do. We've heard from three great speakers now, three experts really, two from around the country that do this for a living, and the gentleman that just spoke that's just like you folks that had this project come to his backyard, tried to do the best he could, trusted, believed in people, and is seeing that sometimes what people say just doesn't comport to what actually happens. And my background as a lawyer, I'm a trial lawyer primarily. That's what I think of myself, that's where I'm most comfortable, and that's what I like to do. And you're only in trial if there's a problem. Something has gone wrong to have a trial, whether it's a medical malpractice event where someone was catastrophically injured by the negligence of a doctor, a motor vehicle accident, or a breach of contract case or others. So I get to see the results of when contracts go bad or when one party doesn't hold their end of the bargain. And I want to be sure to get across to all of you, as the gentleman who just spoke did, that you really want to dot your I's and cross your T's and be very clear on every agreement that is entered into and everything that you're told by TransCanada or any other company that wants to come into your county, your backyard, with a project that benefits them exclusively and ships product out of this country for the world market. So the title here is what can we do and when must we act? Well, we can do a lot. You've heard the other speakers set up quite a bit of things that the federal government has control over and that's maybe the state has preempted, and then of course we have the local government. So today we're going to talk a little bit about what you folks on the local level can do. And the second question, when must we act? Well, that's immediately. That's right now. That's yesterday would have been better than today, but let's do something today and not wait for tomorrow. So how do you protect your county? Well, obviously education, and the fact that you are all here is a great first step. You know, it'd be nice to fill this auditorium, but if each one of you can multiply what you learned today, multiply the questions and ideas that hopefully you get, then you can duplicate and reproduce and spread the word throughout your county and throughout your communities. A quick review, because I hear a lot of this, well, we can't do anything at the county level regarding safety. And like safety is this word that only the federal government has any say over. And here in our local communities, we can't do anything. That couldn't be further from the truth. As has been touched on, safety in terms of pipeline safety at a federal level is related more to the pipeline design, the materials, the fabrication, and the inspection of the pipeline itself. They don't want a county in Nebraska somewhere deciding how thick a pipeline should be or how many rivets should be used or how it should be constructed. If it's crossing the country, we need to have standards, and that's what the federal government's for. But when we come to safety on a local level of things you can do a ton of things that don't even get close to this. So when someone says, well, that's safety, we have to stay away from that, don't listen to that. Run far away. All right, as far as I know, the ostrich is not the state bird in Nebraska, and it's not the mascot of any of these counties in Nebraska. And so we've got to get our collective heads out of the sand, listen to people that have seen things go bad, that have been around the country, that do this for a living, and that have dealt with TransCanada like the last gentleman, and believe what they're telling you because they've lived it and they want to give you a leg up for this time around. So county powers generally, what can the county do? Well, I think I see some Board of Supervisor member here and commissioners, but the powers of the county are exercised through that board. In Nebraska, it's either the Board of Commissioners or the Board of Supervisors. Now, ordinances, obviously at a county level you can pass certain ordinances. Ordinances typically include zoning, safety, building standards, and general regulations. So there's that magic word safety. You can enact ordinances and zoning that have to do with safety. And then zoning, of course, is the power to zone the land in your county. All right, so how do we protect it? Well, we touched on those things. If you have the ability to make ordinances, why don't you go ahead and do that? around the types of issues and items that are going to be important to be thinking about. Zoning. Now this is straight out of the Nebraska statutes, which are our laws, codified laws. And it says, the statute is actually entitled Public Health, Safety, and Welfare. So the county board may make regulations to promote public health, safety, and welfare. Also to provide rules for the prevention, abatement, and removal of nuisances, including pollution, air, and water. Now these are things you can do that are specifically given to counties, that are powers counties have. The general supervision over roads, public roads in the county, is with the Board of Supervisors, the commissioners. That is a place where we can get creative in terms of protections that can be enacted because you have authority over those roads. And in fact, a duty and a responsibility to maintain those roads and to make sure that they are kept up after use, such as heavy industrial users as TransCanada will be in construction. And permits, applications, permit fees. How can we get some of the revenue that TransCanada is shipping to Canada and the oil companies are putting in their pockets? What about the counties? What about the people that have this in your backyard forever with potential unknown risks, unknown liability? What can you do and what should you do? And how can you get some of the revenue for the work that it's going to foist upon you? What about the administrative fees? You didn't ask for them to come here with this project, and now you're scrambling trying to figure out where should it go, how should we handle it, what are our requirements, do we need public meetings? Why can't you get paid for some of those things? And the Nebraska statutes, again, allow, when we're talking about zoning, that the board may fix a reasonable schedule of fees for the issuance of permits. So then the question becomes, well, what type of permits might we be able to enact where we can get some compensation for what is outside of your normal functions at the county level, which is dealing with this special project. All right, I don't want to put anyone to sleep, but the point of this is that the zoning regulations that the county has at your disposal are lengthy. And the reason these numbers are off is because I've taken this directly out of the statute with slight paraphrasing, and I've eliminated some that may not apply to what we're talking about today. But let's just look at number 3, reducing the waste of excessive amounts of roads. So again, it goes back to the roads. You've got to be thinking about how are we going to make sure that this user who's going to be taxing the roads beyond their usual or reasonable wear and tear, how are we going to compensate for that? Because you must, it's one of your duties to be thinking about. Securing safety from fire and other dangers. Okay, so we have some options there, things we can think about. What about protecting the tax base? Well, where's the smartest place for this pipeline or the pumping stations to be located? What about the other future users? Certainly now maybe they're locating it in an agricultural area, but we've got to be thinking forever, and forever is a fairly long time. So be thinking ahead of how where things are located now may or may not protect or infringe or hurt the current tax base or the future tax base of your county. And what about fostering the state's agriculture? Clearly, agriculture is the lifeblood of this state. And not only must we and can we worry about the state's agriculture, it's really should be the primary focus since it's the economic driver. Having our land available for a foreign company to send oil from Canada to Houston is not a primary economic driver, and it will not be one. Go ahead. Additionally, zoning resolutions that you might be able to enact allow you to regulate building setbacks. So, of course, we have the pipeline, which is predominantly going to be underground, except where it has to cross rivers, streams, or roads in some instances. But what about the pumping stations? Those are those beautiful facilities that are out there in the open and that are going to be there as long as the pipeline's there. Well, why can't we regulate how far the setbacks are? Well, we can. I'm going to talk a little bit about fencing. I mean, landscaping. They don't have to be the eyesore that they are. You can do things at a county level to prevent that and prevent that from being a necessary evil of the pipeline. So county power is roads. I touched on this a little bit, but just to make sure you realize I'm not making this up, again, I've cited the Nebraska law. General supervision over the roads is with the county board. The county has responsibility for constructing, altering, improving, and maintaining the roads. And then the board shall have the power and authority for the improvement, maintenance, and abandonment of public roads and enforcement of laws related thereto. So I'm going to get into that a little more, but I want you to understand at a county level, think roads and then kind of have your thoughts flow from what you can do to maintain the roads and keep the roads in working order and shift the cost to the user that is causing destruction to the roads, and don't have that cost shifted to the county. Okay, so defending your infrastructure. That's something that I believe Carl had that I'm picking up on. Defending your infrastructure and who pays for what. So, and also the fine print. I'm going to get to that. The gentleman who spoke before me, get it in writing. That's absolutely right. First you get it in writing, but then what kind of writing is it? The writing that you have is only as strong as the words, the phrases, clear definitions, making sure everyone's on the same page. The deals that blow up so often, and the people that come to my office, the conversation usually starts, but he said, or I thought, but when we talked about it, and then when I got the paper, it was different. Well, okay, be on top of the agreements you're signing. First of all, get things in writing, and second of all, make sure the writings are worth a darn and they're not signed hastily or handshakes and backslapping. Make sure you're having someone who knows, your county attorney or others, read through that, pore over that language. So a few things that we can do, that you can do to put in place to defend your infrastructure and make sure the right party is paying for the damage, for future remediation, etc. Easement agreements. Well, easement agreements primarily are going to be between the landowner and, in this instance, the pipeline. So I'm not going to get into that. Major oil pipeline ordinance. Why couldn't every county have such an ordinance that spells out specific rules, specific requirements, specific reporting requirements that a company like TransCanada would have to report back and provide you information with at a local level? Why is that so wrong? So I would encourage every county to have a major oil pipeline ordinance or similar. Siting permit application. On the front end, you could require a siting permit application at the local level, again, to give you information, knowledge about the project, to require certain information, the numbers of roads that are going to be crossed, where they're going to cross it. You don't have to be in the dark on this. Another item could be standards for the pumping stations. Now, that would be relegated more towards, say, landscaping around them, setbacks. You're not going to get into how they should be constructed or things of that nature, but at least they don't have to be the eyesores that they currently are. Road crossing permits. Why not have a permit for every road that the pipeline wants to cross? Why not have a permit fee for you to go out there or send the city or county engineer, in the case of the county, to take a look at it? The taxpayers are paying for that. Why don't you get something back from that? Why not have a permit or some type of way to get compensated for that? And then, of course, haul agreements. If you sit on a county board, you're familiar, at least generally, with what a haul agreement is. And we've talked about how important it is that counties stay on top of the roads, and not only important, but it's your duty. So haul agreements are important, and we're going to talk about those in more detail. Okay, so a major oil pipeline ordinance, for instance, per county. Would anyone disagree with the following statement? The intent of these regulations is to strike an appropriate balance between our nation's need and our state's need to develop energy resources and the county's commitment to protect the public health, safety, and welfare within the zoning jurisdiction of blank county. Would anyone disagree that that makes sense? I would certainly hope not. I don't think TransCanada or any other industrial user would disagree with that. That's just common sense. And again, the power regarding the health, safety, welfare of your community is given to you by Nebraska law, so why not use it? So if we start with this as kind of our premise, can't we develop a document from there that we can all agree on, and that doesn't have to be so far one way that you never have any development in your community, but so far the other way that you're just the doormat for any company or an industrial user that wants to come in? You've got to strike a balance. Just briefly on this, because obviously in any written agreement, it's a negotiation. Whatever you think you can get in there and that's within the law, you can do so. Parties can agree, or in this case, your county attorney would probably advise you what's maybe pushing the line too much. You can get an opinion from the Attorney General. If you have a question on any ordinance or zoning that you might want to pass, you can always ask the Attorney General's Office of Nebraska. That's free of charge, and they'll give you a written opinion so you don't overstep your bounds if you're worried, kind of as a little insurance policy. So obviously we'd want to address pre-construction filing requirements. What must you know? What are you entitled to know on the front end? Post-construction filing requirements to make sure things are happening post-construction, cleanup, remediation, reclamation, etc. Hearings. Should there be a mechanism for people in your county to be heard and for the industrial user or the applicant to be heard? Beyond just things that happen at a state level. Can the county control and do some of those things? Well, yes, you can. Impact on public roads, that's your duty. You must address that. Pipeline location, there are options for that as well. TransCanada in some cases has agreed to classify certain areas as, I don't remember the key phrase right now, but it's fragile or highly sensitive areas. So you can negotiate those things. Obviously a wellhead protection area or other areas that are specifically identified by statute must be avoided. Related structures and facilities, again, don't forget the pumping stations. They're above ground and they're going to be there and they're going to be seen and visible for years and years to come. Easements and right-of-way agreements. If it was me at the county level, I would like to see the piece of paper that's going to govern the agreement that the pipeline's going to have with the citizens and the residents of my county. I'd like to see that on the front end. I'd like to publish that and make it publicly available. There's no reason to hide behind it because that is the one agreement that controls the rights, the responsibilities of, in this case, TransCanada and the farmer, the rancher, or the landowner. Pretty important document. And along those lines, your state legislature, your attorney general, and your governor completely dropped the ball and fell asleep on that, didn't do one thing in terms of developing a Nebraska easement or a standard baseline of terms and provisions that are acceptable to Nebraska. They let the landowners fend for themselves and hope that you get the best deal you can, which is where NEAT, Nebraska Easement Action Team, comes in, of which I'm proud and happy to be a part of. Also, emergency services spill response. I won't go over that too much. It was covered very well by Paul earlier. Public inquiries and complaints. Should the county have to take all the calls from the concerned citizens, neighboring landowners of what's going on? What type of burden is that on you and your resources? The taxpayers of this county are paying for that person to do the job they already have. Should that be foisted upon them as well? Or should TransCanada or the applicant or the user have to make someone available to field those complaints? Should they have to post all complaints on a publicly available website or for viewing somewhere in the county? Again, transparency. A lot of these things go back to, if this is such a great project and you're such a great company and you're just like my neighbor, well then put everything out in the open. There doesn't have to be any secrets. That's not offensive to say. Let's just be honest and get this out in the open. Abandonment of pipeline. Reasonable minds can differ on this. Some might say taking the pipeline out can create more or just as much havoc than the construction in the first place, because obviously you're going to have to dig it out. If you can't do it right after harvest or before planting, you will interfere with the planting season if it's farm ground. In my opinion, from the legal side of things, I would say that's an absolute must. Now, maybe you have a provision where on a one-on-one basis you can negotiate with the landowner. So the landowner might be able to extract payment for the right for TransCanada not to have to remove a certain section on their land. But at least it should be open for discussion. And again, in my opinion, and on behalf of NEAT, which I'm going to announce here today for the first time, we will not advise and we would not agree to sign any easement for any landowner in the state of Nebraska that does not have a clause that TransCanada will remove the pipeline after their use is done. It's an absolute must. They have to do it, and we're going to require them to do that. You do not want this pipeline rotting under your ground so your grandchildren and others can deal with it in the future after TransCanada and the executives that are pushing this through now are long gone. Indemnification, pretty important to hold the county harmless for any damage that TransCanada, again in this instance, may do to the roads or may cause to other structures, either when they're constructing or post-construction and then at abandonment. Okay, I'm just going to probably jump to the middle here. When you're doing these ordinances, the point is you've got to be thinking about what you know now and what may be, which makes it pretty difficult. But if we have a pipeline running parallel, say, to a roadway, at some point it's going to have to cross another roadway. On either side of those roadways, you likely have irrigated quarters. You likely have land that's kicking off, if it's an irrigated quarter, probably $7,000 a year in property taxes. Well, by having the pipeline in a specific location, at this date right now, maybe it seems fine. But what is prevented in the future? What are your citizens and taxpayers, the people that have built your county through their hard efforts and their payment of property taxes, how might they be affected in the future? Will a farmer be able to run irrigation pipe to his field across the road by going under the road if it also means going across where this pipeline is? Is that going to be allowed? And if it is going to be allowed, what are the requirements? What are the limitations? Who must be noticed? Does TransCanada have the ultimate fiat power to say yes or no? You've got to be thinking about these things. Proposed limits on noise from pipeline facilities. Again, the pumping stations. You can't tell them how to build a pumping station, but there can be limits to the amount of decibels. We see that with wind farms. We see that with transmission lines. So be thinking about those things that might be able to be impacted via local zoning. All right, I touched on this a little bit. For the pumping stations or related structures and facilities, again, just not the pipeline. We've got to think about the other items that go along with it. Screening of a substation or the pump station. Again, landscaping, can we make it look a little better? And why not an inspection fee to make sure that they're complying with the screening and that they're maintaining and that they're mowing, okay? Other things that you might be able to get creative about in terms of bringing some revenue back in to the county based on your efforts that you would not have to do but for the existence of this pump station, of this pipeline. Okay, other ideas. No liability for spills resulting from normal farming practices. We're going to try to work this into the easement agreement between the landowners and the pipeline, but I'd like to see this or a variation of it worked in somewhere. It could be in the ordinance, the major oil pipeline ordinance that the county might enact, but it's pretty important to think about. And then normal farming practices. Well, what is that? I've heard talk that TransCanada will not allow, quote, unusually heavy equipment, end quote, from crossing their easement. Well, how big are planters these days? And how big were they 50 years ago? If this is a 50-year project, we have no idea what size of equipment you might need to run your operations or if that will be unusually heavy. And who defines that? Again, do they get the final say on that to tell you you can't cross your field with your new combine in the year 2040 because it's twice as big as combines now? I don't know, but we've got to think about those things. What impacts will this project have on you in the future that we now here can't imagine? But because we can't imagine it, we can't be that ostrich. We have to do something. We have to at least think and embrace the fact that we don't know everything, so therefore we must plan for those things that we don't know, but that are somewhat foreseeable, and that is farming getting bigger, equipment getting larger. No liability other than gross negligent or willful misconduct of a landowner or its agents. Again, in the easement agreement between the landowners and TransCanada, TransCanada always likes to say, well, if anything goes wrong, we're responsible. Well, that's absolutely not true if you read the agreement. If it's the negligence of the landowner, you're responsible. And negligence means an unintentional act, damage that occurred from an act that was not intentional, okay? I think if it's their project, they're making the billions of dollars off it, unless the landowner intentionally tries to damage, destroy, or impair that pipeline, that pump station, it should be TransCanada in this case, or the industrial user's responsibility to pay for that damage. They shouldn't be able to foist it off on you by saying, well, you used unusually heavy equipment that day, didn't you? And they will do that, you better believe it, if there's ever a spill. Next. Okay, along these lines, 50 years, a lot can happen in 50 years. So we've got to think forward, and we can't be afraid to just do what we've always done, live in the status quo, be the victims of inertia. You've got to think about the future. Maybe we won't even use roads in 50 years. I don't know. Maybe we'll have hovercrafts. And now you can't think of everything, but you at least should be thinking about the possibility that life could be different in the future. But if that pipeline is still there, you're going to have a handicap of some sort because it's going to be there and you're going to have to deal with it. All right, this is looking a little long and lengthy. Again, ideas for permits, fees. I keep thinking, my goodness, the legislature, the state of Nebraska completely failed, 100% failed. They had the opportunity of a lifetime to make this project and the granting of authority of eminent domain to a foreign company contingent upon payments annually forever as a revenue source for this state. We did not do that. Why wouldn't we do that? I mean, I'm totally flabbergasted by the fact that we had that opportunity. They didn't have the power to take all of your land, but for the legislature giving it to them. And now what did we as a state get back for saying foreign companies shipping oil out of this country, you can take Nebraskans' land? What did we get back for it? Well, not a damn thing. Okay? We didn't get a damn thing back for it. And now it's kind of up to you either to get upset enough to maybe change this for the next time around, or at a local level at least try via permits, application fees to get some of this money back that the state just let fly away for no good reason. Some of the ideas, we've touched on a few. Haul road permit application fee, a road crossing permit. What about underground structure identification permits, a remediation plan permit, filing fee if, in this case, TransCanada sells or changes ownership? Who are we dealing with? Who do we talk to? What if the Chinese make a hostile offer for their stock on the Toronto Stock Exchange and now you're dealing with China? These are all real possibilities that people aren't thinking about. And I don't blame you because no one's mentioning it because it's not in TransCanada's interest for you to be thinking. Stop thinking and then they'll just get everything they want. Administration fee to cover record keeping. The poor man or woman who's in the county right now who's busy, buried, processing driver's license or I don't know what permits. What about them? Are they going to have to take over the responsibilities of all the admin related to this project? How about helping them out? How about getting some type of a fee back to you and the taxpayers to cover what inevitably will come from this project? Go ahead. All right, road crossing permits. They don't have to be scary. Here's a one-page permit. I think this is from Williams County, North Dakota. Or no, it looks like Texas. It's from Texas. I've looked at them from all over the country. But again, it doesn't have to be burdensome. They can be very simple but yet powerful agreements and permits. Road crossing permit. Okay, the key here, how about generating some revenue and compensating the county for what they're having to deal with? Why not a flat fee per road crossed. That's part of this road crossing permit that we're going to do. The county will issue a permit if you pay a fee for every road you cross, because you're going to want to go out there, you're going to want to investigate it, you're going to want to inspect it, you're going to want to check up on it, because again, that's the county's duty to maintain the roads. That's your responsibility. You must do that. Why do it for free? And then what about renewable annually? That pipeline is going to be there. There's no doubt going to be some maintenance. What if there is a spill, God forbid? What if there is a section of pipe that has to be replaced? Well, they're going to be coming down your roads with the big trucks. Will the haul agreement that you signed 10 years ago, will that still be in effect? Or how is that governed now, 10 years later? Good question. But why not have a renewable fee per road crossed in the county every year as long as that pipeline's there? I don't see anything wrong with that. There's other ideas here as well. I don't need to get into all of that because I think the key is kind of thinking about the fees and the things that you can do to generate some revenue. But simple things like marking the location with a post on either side of where the pipeline is. Let's not have your grandson in 30 years out combining or out disking, doing something in the field with heavy equipment, and he forgot the pipeline was even there. I mean, let's make sure they let you know where it is so you are on notice at all times. Good. Haul road agreements. Some of the things that we've talked about could be combined into a haul road agreement as well. It can be a revenue mechanism and as well as a defense or defending the county infrastructure, a mechanism to do that, a document you can sign to do that, that governs the rights, the responsibilities from now and into the future in terms of that user using your roads. Important provisions: how to get the applicant to pay for future inconvenienced alterations, paving, relocation, reconstruction, etc. They must be responsible for accelerated deterioration, repairs, improvements, additional maintenance expenses beyond the post-construction time when they're coming back to maybe check on a provision or a portion of the pipe or a pumping station or something. We need to make sure you're covered for those instances that could be in the future. Clearly established responsibilities, obviously. Try to avoid vague language that leaves it in doubt who must do what, when, where, and why. Establish a baseline. This isn't very objectionable. What do the roads look like now? But how do you establish that baseline? Oftentimes agreements have a third party. In this case, TransCanada and the county agree on third party XYZ to go out and do a baseline evaluation. Okay, that sounds fine. That in of itself sounds fine. And of course, the pipeline, in this case, should pay 100% of that cost. Again, you would not have to be reviewing those roads but for their desire to cross them. But what about county having the final say? I think the county always has to reserve having the final say. I've seen some of these agreements, and I think I'm going to get to it, where the agreement is the third party will be the arbitrator and have final say of any disagreements or any disputes. Now, when you read that once, it thinks, well, that kind of makes sense. We can trust, Joe Blow. I've known him for a while. He'll do okay. Well, think about that. Do you want a third party, maybe one person or maybe two people in a local company, to be the final say on any type of disagreement? I would urge you not to do that. If the disagreement's bad enough and it's over enough money, you want to be able to go to your local courthouse where taxpayers in your county will be on the jury, and it'll be TransCanada in this case on one side and your good people from the county on the other side. I mean, do yourself a favor and don't just put it in the hands, a final decision with no review, no appeal process, because these decisions, these disputes could be in the millions of dollars potentially if a company really destroys the roads or you have a dispute over them not holding their end of the bargain. I've seen contracts that give the county 15 days to say yay or nay, everything looks good. I've seen contracts that give 30 days to say yay or nay, everything looks good. That's a lot of pressure to put on yourself. So they just repaired the road, and what time of year is it? Has there been a freeze? Has there been a thaw season? What cycles have gone on? I mean, they want you to say, yep, looks good right now, because that stops the clock on their liability. They are footloose and fancy-free. What looks good to us, anything else is on you, county. So think about extending that out a little bit. You may want more time. You may need more time, especially depending on the season. What if all the grounds, well, yeah, I mean, depending on the season, depending on the use, depending on what's going on, don't handicap yourself by such a short time frame. We talked a little bit about being responsible for future. Again, when does this haul agreement, if you have one, stop? Does it govern 15 years from now? Or does the haul agreement with these provisions terminate the date you sign off after your 15 or 30-day inspection and say, looks good to me? You got to really think about that. What governs in the future? And if there's nothing, then how are you going to deal with that? Indemnification agreement, I mentioned that earlier. Performance bond, absolutely critical. Holt County, in their haul agreement, they have a $3 million performance bond. Okay, I've seen bonds in other counties, I've seen agreements from other counties that don't even have this, no bond required. They will pay the bond, okay? Get them to pay a bond, absolutely critical. Again, insurance. And if they have no intention of stiffing you, there's no reason not to put up a bond, right? Absolutely no reason whatsoever. To reiterate, you've got to think post-construction as well. Other affected properties, bridges, if you're in such a county where you have bridges or related structures that might come into play, it's not just looking at the road in a vacuum. You may have, I don't know, on-ramps or off-ramps potentially. Fight over the extent of damages. I already talked about this, but again, if it were me and you were my client and I was advising you, I would really try to say that any disputes we can't resolve between ourselves, or if we disagree with a third party's determination, that there is an extra layer of how to determine that dispute, and that would be the court system. I mean, we only have the greatest system in the history of the world, the court system, the trial by jury. It's not perfect, but it's the best there is, so why would we give that right away? I just would not ever, I wouldn't do it. And language is so important. You got to have the agreement, and then you got to understand what it says, and it's got to be clear. This is right out of a haul road agreement I've seen. X, the applicant, the user, will use reasonable efforts to complete restoration in a timely manner. I don't know what that means. I have no idea what that means. I do not know what is reasonable. I don't know what's unreasonable. Who's going to tell me what's reasonable? What's reasonable in July? Is that also reasonable in December? What's reasonable in 2013? Is that reasonable in 2053? I don't know. A timely manner. Whose timeline are we on? Now, this isn't that uncommon, but I take this type of phrase because sometimes you do want wiggle room. It can help both sides. But it's simply an illustration that you want to really think about each word, the interplays, and what they mean. Okay, now listen, counties can be proactive, okay? This slide, if you can't see it, has these two guys, they're just yucking it up at the bar here, having a couple drinks, and at the bottom, here's to missing the big picture, okay? Don't be these guys. Do not miss the big picture. Do not be the ostrich. Counties have power. Citizens have power. You have rights and responsibilities, and don't be afraid to reduce them to writing. Don't be afraid to negotiate and negotiate firmly. Don't be afraid to say no when they hand you their template agreement and say, well, everyone else has signed it. Whenever you hear someone say, well, everyone else has done it, you probably want to do the exact opposite, okay? Don't be these two guys. Don't forget the big picture. You're making decisions today for the great-grandchildren you don't even have yet. So think, don't be afraid, be proactive, and do the best you can now because you have the responsibilities for future generations. Thank you very much.